Thank you, everyone. Please be seated. Our next case this morning, set for oral argument, is State versus Smith, and it looks like the parties are ready. Ms. Conroy, you may begin.
May it please the court, counsel. Good morning. My name is Mary Conroy. I'm an attorney with the Appellate Defender's Office, and today I'm here representing Taylor Smith. Mr. Smith was convicted of sexual abuse in the 3rd degree under what's colloquially known as the statutory rape alternative. He raises 2 main issues today. First, that the district court abused its discretion in sentencing him, and that second, the district court's inclusion of a firearms prohibition in his sentencing order is invalid and it was improperly done. The firearm challenge has been made under both the Second Amendment and Iowa's recent amendment, Article 1, Section 1A. These 2 constitutional provisions require different analysis for this court, but under either, the firearm prohibition in Mr. Smith's sentencing order is invalid.
The sentencing order, let me back that up. Was the firearms prohibition actually part of the sentence, or did the sentencing order just give him notice of the legal consequences of his sentence, sort of a collateral consequence?
I think it is part of the order. As this court, I guess Justice McDonald and Hess said that collateral consequences are made part of the order and a term of the order by the inclusion of it in the sentencing order. And so I do think it is part of the order, even though it's labeled miscellaneous notice. And I think the collateral versus direct consequence of the conviction misses the point, because we do have collateral consequences in sentencing orders that this court has found unconstitutional or invalid.
It strikes me that the collateral direct, what that kind of gets to is whether the defendant needs to be disclosed, whether the consequence needs to be disclosed to the defendant before they plead guilty. That's really what that drives at. Here we're talking about an issue of appealability. In appealability, you're only allowed to appeal conviction and sentence. That's what the statute says. So is this part of the sentence? Convince me of that.
It's part of the sentence by virtue of being in the sentencing order and saying that felons cannot have firearms. I think if there was some sort of notice that was in the court, or labeled a notice that was in the order that was wrong or arguably wrong, we would be in the same position asking this court to strike that order as part, or as strike that term as part of the term of the sentence. And if
between a sentencing order that directs the defendant to do or not do something, and then this provision, which is under, I'm looking at the sentencing order, it just says miscellaneous notices. And it has a notice about benefits, about voting, about firearms, about immigration. The judge isn't telling him something that he can or can't do. He's just saying there are these other statutory provisions that are now triggered because of your conviction. So what's the order that's in the sentencing order that you're appealing?
I think it is that term that people convicted of felonies cannot are permitted to possess or ship, transport firearms. That piece of that order is going to be one relied on arguably by sheriff's office if the defendant wants to try to get a firearm, or
wasn't in the sentencing order. I mean, the prohibitions in Chapter 724 would still be applicable, wouldn't they?
I think if this court finds it's unconstitutional as applied to him, then they would not. I acknowledge that the defendant might have to go through further process to try to get a firearm legally, both federally and in the state. If the court just strikes the provision, which is what we've asked for, versus declares it inapplicable to him. But this is the first step, because anyone looking at this order is going to see defendant was convicted of a felony, and here it says he can't have a firearm. So the first step in this process of legally being able to, or trying to exercise Second Amendment rights or Article 1, Section 1A rights, is to get this provision struck from this order, and then go on from there, Your Honor.
Let me quote exactly what the statute says, because that governs, our jurisdiction. Right of appeal is granted the defendant from a final judgment of sentence. All right, so is this part of the judgment of sentence?
I mean, it's our position that this is, as it is put in the sentencing order, it is part of the sentence, and it is a term that the defendant can appeal from. Otherwise, I don't know what his remedy would be. I mean, this court has always let people
To it separately from this action?
to get this provision struck from his court order. I don't know if,
In order?
I guess I don't know if that's possible.
For a permit upon being released from prison and then attack the prohibition that way.
But I think the U.S. Supreme Court has said that you don't have to wait to exercise your fundamental rights. And this is his first step in doing that, is trying to get this out of the order, so then that opens up avenues that he can pursue later, including asking for a permit, excuse me.
Few Court of Appeals cases that were referenced, Woods, I think, and Grover, and Richter, I think, from last year. Those all, I think, involved no, or at least Woods and Grover involved no contact orders, where it specifically said, defendant, you cannot possess a gun. Is that different than what the judgment is in this case?
I don't think so. I mean, I think this is telling him as a felon he cannot have a gun, and so it's part of the order and as a term. And we know from Second Amendment analysis, this order does cover his conduct, and also the government has the burden to show that there's firearm regulation that's consistent with the nation's historical tradition of regulatory actions against or towards firearms. And arguably under the Iowa Constitution, the new provision, that is even stricter, because we're told that you have to apply strict scrutiny to any and all restrictions on the right to bear arms.
Not be able to reach the Iowa Constitution if the Second Amendment challenge fails, because then there's a valid federal prohibition. It wouldn't matter whether Iowa Constitution gave him more protection.
You have to look at that, because the Iowa Constitution obviously can't override the federal statute, but there's still an Iowa statute at issue here, and laws can change at any point, and so he still would need that determination of whether or not this the Iowa Constitution also would violate or would be violated by the statute.
This is, he's convicted of basically statutory rape, but in evaluating the firearm prohibition, could we look to the underlying facts of the case, that this was a sexual assault against the will of the victim?
So, or not without like a separate proceeding that's looked at, that he has an opportunity to show that he's not dangerous. There wasn't a weapon used. I don't think the state hasn't provided any law that is a historical analog to this, and the elements of the crime itself do not require force. I think that under a different framework, it is possible that the court could consider past behavior in determining whether future dangerousness is possible, and whether that means that he could have his firearm rights restricted, but not under these circumstances.
finding of dangerousness in this case. Looking at the no contact order that was issued, and the district court says there's probable cause to believe a violation of 7093 has occurred, and the presence of or contact with the defendant poses a threat to the safety of the alleged victim, persons residing with the victim, or members of the alleged victim's immediate family. And then the sentencing order continues that no contact order.
I don't think that's dangerousness in the context of moving forward and in his actual firearm rights or his right to commit or to have a firearm. It's
That.
because the offense wasn't with a weapon. There's no opportunity, it doesn't appear from the record that there was ever an opportunity for the defendant to enter evidence on why that hearing shouldn't, or that order shouldn't have been put in place. My understanding is that those usually just happen automatically in cases like this. So it wouldn't have that individualized hearing that Rahimi talks about, where the defendant is able to put on evidence and show that he is not a danger. And I don't think it's necessarily saying anything about his dangerousness in the future with a weapon, which I think is what is required constitutionally to restrict his firearm rights.
Contact order that Justice McDonald quoted, that finding of dangerousness, bring this case within Rahimi that would defeat a Second Amendment challenge?
Because Rahimi is pretty limited if you look at what it actually held. First of all, it was only a facial challenge, so it had to show under any circumstances it would be unconstitutional. But it also was very clear that it was only talking about temporarily disarmament. And this is obviously a lifetime disarmament with no opportunity to regain those rights.
Concern I have about your argument, Ms. Conroy. I mean, earlier you were saying the prohibition, it's part of the sentence, it can be part of this direct appeal, and it can be struck down. Now when we get into the merits, you're saying, well, you know, there's this evidence that this was really not just a statutory rape, but a rape. It was against her will, overcome by force. He's 23, she's 14, he knew she was 14, all those things. And you say, well, he needs an opportunity to show that, you know, he's not a threat to her, and there needs to be some kind of evidence that he has a chance to present. If that's the case, how can we decide that on a direct appeal? Doesn't that suggest that your remedy ought to be some separate form of action?
I think the way to do that is just to strike it from the order. Because again, then we're just left with, he might have to pursue other options. But if it's out of the order, that is the first step, because the court did not make this finding, this individualized finding, and he didn't have the chance to admit any evidence showing that he would not be dangerous in the future.
From the order, it seems to me, doesn't solve the issue. I mean, we could say we could excise this paragraph from the order. The prohibition in 18 U.S.C. 922 and Chapter 724 of the Code still apply, whether or not the judge says it or writes it in an order. So I'm not sure why, maybe this goes back to the original question. I'm not sure why this is part of the sentence, because whether or not the judge said it or wrote it, the prohibition still applies.
I guess from that standpoint, I mean, you could remand it to see if the prohibition should apply to him, and let him present those facts and let the state argue against it. But I do think just having this order out there with this information that may or may not be incorrect is improper. And we want people to be able to trust a court order that it's correct and be able to rely on it. I also think if in it that it might not be correct, including that also has a chilling effect on people who do want to exercise their Second Amendment rights or Iowa constitutional right to bear arms. And so I think the answer is striking it. I acknowledge that he might have to do further things depending on how this court rules. well, certainly for federal law, although I guess it's still not clear if this court found that this statute was unconstitutional as applied to him, if because it's a state statute, I'm not sure how the feds would treat that, if they would treat that as a restoration of firearm rights, and then he wouldn't be subject to the firearm code federally. But those are all open questions. And so I know that there is going to be some sort of process, short of being arrested and having to challenge it that way, for him to get back his, or make it clear that he still has his firearm rights. But this order is the first step in that process.
On the merits of your Second Amendment argument, the Eighth Circuit in Jackson, I think, said, we're not going to go, at least they're not going to go, crime by crime. If it's a felony, then it passes muster. And then I'm blanking on the Sixth Amendment, or the Sixth Circuit case involving the marijuana possession, which is a very different crime than even a statutory rape. What's the best federal case that would say that that would allow you to proceed on the merits of your Second Amendment case?
Is range, which I cited in the additional authorities, and just relying on Justice Barrett, then Judge Barrett's dissent in the Cantor case, I think lays forth why a blanket permanent disarmament ban is unconstitutional under the Second Amendment. And I see I'm almost out of time if there are no other questions. Thank you.
Thank you, Your Honor. May it please the court. Counsel, this is not a sentence. This is a notice of a firearm prohibition. Grover calls it an additional directive, or you can also call it a collateral consequence if that means something to you, or if it doesn't, Justice Mansfield. But in any event, as Justice McDonald, as you pointed out, whether this is whether the judge tells him about this or not, it's still the law. And so 922G1 is still a law, 724.26 is still a law. Whether he's noticed of it or not doesn't matter. The other miscellaneous notices are about federal state benefits, voting rights, immigration consequences, and fingerprinting. I don't know if any of those apply to Mr. Smith, and that's sort of the point, is these are not tailored to an individual person, as 901.5 would, Section 901.5 would have a sentencing judge do. These are just notices of other things that could possibly happen to you. Now, yes.
Address the 31A notice that was provided.
And what part, I'm sorry, Justice, what part of it?
The firearm notice that specifically says that there was an order entered that deprived you of your rights, and is that more of a direct order that brings it within the sentence?
I still don't read it as an order, Your Honor. It's captioned notice of firearm prohibition pursuant to Iowa Code Section 724.31A. It does list as the criteria, and I think this is what you're getting at, the felony conviction, and it cites these to the state and federal statutes. But it just informs Mr. Smith that his information will be forwarded to the FBI and to the Iowa Department of Public Safety for inclusion in their databases. And Chief, to your question, this is how you would challenge these. So he could go to DPS and say, please issue me, please remove my name from this database. They would ask him, well, are you a felon? He would say yes, and they would say, sorry, we can't remove you from this database. At that point, he could challenge that before an administrative law judge. I think I'm on safe ground in saying the ALJ would deny his claim, and then he can raise a 17A petition, and we're off to the races there. That's effectively what happened in Range. Range is a gentleman who was convicted of food stamp fraud 20 years prior to this application. Now he wants a firearm. He petitions, he sues the Attorney General of the United States and the Director of ATF for injunctive relief to declare that he can, in fact, possess a firearm. And that's and then we proceed from there. That's a different procedural posture than we have here. That's more like the administrative relief that I proposed under our state 17A procedures. The other procedural posture that we see in federal courts, especially surveying post-Rahimi cases, is a motion to quash or dismiss the indictment. I'm speaking of an indictment for being a felon in possession of a firearm under 922G1. So those people, like Daniels, for example, in the case that my colleague cited in her notice of additional authorities, he has this underlying a drug charge. He gets arrested for being a felon in possession of a firearm under 922G1, moves to dismiss the indictment, and then that allows us to review these cases. But we
Possess a firearm and then get arrested before he can challenge this. You're not suggesting that, are you?
that not happen, but so he does have that administrative relief, but if that were to happen, then he could move to quash the indictment at that time, just like Daniels and the other federal litigants that we see do it.
Practical consequences of whether this is appealable now or not is who pays for the lawyer. If he's indigent, he gets a public defender or a court-appointed lawyer to challenge a firearm prohibition now. But if it's not appealable because it's collateral, then under 17A, he doesn't get a free lawyer, does he?
For legal aid, he might, Your Honor. Otherwise, I had not thought of that, and that's a fair point, but that doesn't defeat the procedural posture and the rules that we have for standing and whatnot.
Are you familiar with the Richter case from the Court of Appeals from last year? Okay, so that's a case where an individual was convicted of possessing marijuana, and the judge said, I find you to be an unlawful drug user, and so I'm going to give you the firearm notice. And on appeal, they ended up, there was a motion to suppress, and the Court of Appeals ended up overturning the marijuana conviction. But in that case, where the district court made a finding as part of her conviction that you are an unlawful user, and I am therefore going to provide this notice, would that be part of the sentence so that then that defendant could have raised that on direct appeal?
I still don't think so, Your Honor. And I'm familiar with Daniels and Connolly are the two Fifth Circuit cases that have the same idea, the unlawful drug user in the federal courts. And
I'm not talking about the merits. I'm just talking about whether or not it would be proper to address it on direct appeal.
I still don't think so. From what you're telling me, it still sounds like it's just a notice of firearm prohibition.
If that person then went to try and challenge the firearm prohibition, get a gun or get a permit or seek a deck action, would that district court's finding that she was an unlawful user be res judicata in the next case?
No, I don't think so, because it would not be, I'm blanking on the res judicata factors, but it has to be determinative of the first issue, of the first case, right? So that doesn't strike me as being determinative of the issue in the second case.
Would we be able to reach the 1A Iowa constitutional claim if the federal challenge failed and there was a valid federal prohibition?
Your Honor, I think under federalism principles, the federal would control. The only way I'm thinking of it is the only way I'm thinking that it might otherwise be otherwise is if for some reason you decided to, because you're applying two different tests now, the historical tradition one in the federal and the strict scrutiny under the state, maybe that would be a theory under which you could approach both, but I think generally federalism would apply and the federal decision would trump.
Argument, we just heard that because it's a felon in, we have a state statute for prohibiting felons from possessing firearms. Is that a hook to reach the 1A issue now?
Well, not now. I don't think now, but I still think I think I would give the same answer no matter what.
Could reach the issue, the challenge to the prohibition. What impact, if any, does the no contact order and the finding of dangerousness have to resolving that issue?
A few different answers to this. So I have yet to see a court that applies traditional tiers of scrutiny analysis to one of these cases even get into the facts of the case. The state court cases like Eberhardt and Clay that this court has cited before in NS, those are from Louisiana and Missouri, and then all the federal cases that I read before Bruin and Rahimi all said felon is sufficiently narrowly tailored to pursue a compelling state interest, and we don't need to get into the facts of the cases. So that's one half of the answer. Dangerousness, not all the federal courts are even looking at this dangerousness. So Jackson, and from the 8th Circuit last year, seems to not even care. I mean, they seem to be saying status quo, that we've been saying felons is good enough for a long time, and we're going to keep saying it. And that's how I read Jackson. Certain other cases in the federal courts do look to dangerousness, and I think there's some of that in Range and Daniels that my friend cited. I'm also thinking of Williams, which is a 6th Circuit case that came out last year. They talk about dangerousness. And so then I do think there has to be that finding. But that's only after you've gotten through those other layers of things to say that we think dangerousness is a factor worth considering here. But then I do think, yes, the no contact order, and I would even point you to the findings in the district court's substantive order. It was a bench trial, so it's making these findings as finding that Mr. Smith remains a danger to KS, and that there's this ongoing dangerousness, that there was this, the predicate dangerousness. And so I think we do satisfy that, but I'm not even sure that this court has to get down all those layers to reach that question. We haven't talked about the sentencing issue yet at all. It's Mr. Smith's burden on appeal to show that the sentencing court abused its discretion. I think the way that he would attempt to show that is that the district court was unaware of its discretion to impose a lower fine than it did. As this court is well aware, there was a range of fines available to the district court as of June 2020 or July 2020 and thereon. And just because the fine that was imposed is not the minimum fine that was available does not mean the district court abused its sentencing discretion.
I'm a little confused by that because it looked like the fine and surcharge were being appealed, but it also looked to me like the court suspended everything but the $90 surcharge. Is that right? I think
that's right, Your Honor. Yes.
Something that was suspended?
That's what's happening.
A situation where a suspended fine would come back to become a real fine?
I think there could be a situation, but I'm not aware of what that would be. We're left here with a couple of situations, as these questions indicate, where nothing has happened to this person yet. He is aware of his status as a felon, and I guess that is something. But even if he were not aware of that, these laws would still apply to him. So I'm not entirely sure well, I guess I'm sure what he's challenging. I'm not entirely sure what relief this court could provide to him. The court can't unwrite the notice, and even if it did, the law would still apply. If there are no further questions, I'd simply ask this court to affirm. Thank you very much.
Thank you. I'll give you a little time to get here. That.
Too. Thank you. Justice Mansfield, I'd like to start off with a response to your question about suspending the fine. And I think on a broader picture, yeah, he is arguing that fine, the court did impose the fine, but then suspend it. But the larger picture is a defendant is entitled to a district court that is aware of all of their sentencing options, and that includes a lower amount of fine. And the reason we have that principle is to protect judicial integrity. We see this all the time in resentencing where we get a client a new sentence and they get the same exact sentence. On appeal, we don't let the state just say, oh, it's fine, like they'll just get the same sentence. The defendant is entitled to a district court that is aware of all the sentencing options when they are sentenced, and that includes the minimum amount of the fine. And I think here, and this court has always required resentencing when the district court was not sure of its discretion or if it was unaware that it had discretion. And so that's what we're asking for here. And I think that is clear and borne out in the record when you have someone who was charged later, or there was a delay in the offense and then the trial information or in his arrest. And the penalties did change. And there's no indication in the record that the judge was aware of that. And then everything in the record indicates that the judge was unaware. As we pointed out in our brief, the imposition of a $90 surcharge instead of the $100 without saying anything, the same with the criminal service surcharges, and then the order itself having the minimum fine as $1,370 instead of $1,000, which would have applied at the time the defendant actually committed the offense, and so that would apply for him. And obviously, I think if this court finds that he's entitled to a new sentencing that vacates the order, and then we're kind of back where we are at the firearms prohibition. I did kind of want to circle back to my colleague's references about strict scrutiny. I think this court needs to take into account the fact that many of the cases that the state has cited were pre-Bruin and not applying strict scrutiny at all. They were either applying intermediate, most of them were applying intermediate scrutiny. And so I don't know that they're really on point. Especially because of this court's, the standard of strict scrutiny is very, very decided and a settled point of law. And so we really do need to look at whether there's compelling interest and whether or not it's narrowly tailored.
You know, where we're headed, I mean, I'm just musing out loud, but I'm interested in your thoughts, is there's going to end up being two modes of analysis, because the U.S. Supreme Court has said in Rahimi and Bruin, we look to whether the restriction has an analog in what was being done in 1791. If there's an analog, then the restriction is okay. The legislature and the people of Iowa, in adopting Article 1, Section 1A, have instead said there's a right that's protected by strict scrutiny, which is a mode of analysis the Supreme Court, U.S. Supreme Court, has rejected for the Second Amendment. So it seems to me we're going to have two different modes of analyzing these issues depending on which amendment we're talking about. Am I right?
Yeah, the U.S. Supreme Court has rejected any kind of means and scrutiny. The Iowa Constitution does require strict scrutiny. In this case, I think strict scrutiny is probably harder for the court to meet, or the state to meet, although even under the Second Amendment, I don't think they've provided a historical analog for just a blanket lifetime disarmament of felons. In some cases, I know Justice Kavanaugh, when he was a judge at the district court circuit, the DC Circuit Court, said that sometimes the Bruin test is actually going to be easier for them to meet. It's going to be a rare law that passes strict scrutiny. And I see I'm out of time for these reasons. Okay, for these reasons, Mr. Smith would ask that this court vacate his sentence and remand. Thank you.
Case versus State versus Smith is hereby submitted. We'll have a brief pause here while the next attorneys get ready for Christensen versus Story County.